Good evening, everyone. For those of you who do not know me, I am Steve Fox from Border City Financial. And tonight I am thrilled to be hosting Tony Grassi from Grassi Law. I have been looking forward for some time to having Tony on our webcast. Tony is our expert in estate planning. I've known Tony for I don't know, how long, Tony? 20 years?
It's been a while, boy, oh boy.
Yeah, it has been a while. So, he's got a couple gray hairs, and so do I. So we've known each other for a little while. But Tony is definitely our go-to expert on estate planning issues, and we've been very much looking forward to having you on to deal with issues evolving around estate planning, because this is an area that just continues to change and change and change, and there's lots of confusion with people regarding how estates get settled and how do I transfer things most efficiently to the next generation. And so it can be a very, very confusing area for a lot of people. So we're really looking forward to you sharing with us at least a little bit of information about estate planning tonight. I'm not sure how much we'll get through. So without further ado, I wanted to introduce Tony. I'm thrilled that you're here, Tony. This is an issue that's near and dear to a lot of people's hearts, and certainly an area that can be incredibly confusing. So I'll hand it over to you, and we're looking forward to what you can share with us.
Thanks so much, Steve. Thank you for everyone out there for taking time out of this beautiful day to be here, talking about, death, taxes, wills, power of attorneys, all that grand stuff. I don't have much time today to really cover all of the issues that are out there, but what I was hoping to do is leave you with a few nuggets today so that you sort of have a litmus test, if you will, of things that you need to look at to make sure that you're protected. Now, this is my first podcast ever, so I'm not sure what you can see. I mean, boy, oh boy, I'm looking at myself thinking, is that what I really look like?
Yes, it is.
Oh my God. Anyways, that being said, really the starting point for everyone out there today is everyone, when it comes to wills and estates and all of that kind of stuff, has to ensure that you've got proper documents in place already. The question of should I have a will or should I have a power of attorney should be long gone. And the answer is really the gold standard is that anybody over the age of 18 years old should have a will, should have powers of attorney. And it's not always immediately apparent why that's the case, but really the main thing is not only these documents deal with your property, but they deal with control over your person, both while you're still with us and then once you pass away. And that's why you need all of the documents, the will being the document that governs matters once you pass. And then there's two power of attorneys that you need to have in place. One being one for personal care matters like healthcare issues. And if you choose to have a living will directive talking about the final healthcare decision, it needs to be included as part of that document. And then the one most people are more familiar with is the financial power of attorney. So, pay mom and dad's bills or brother or sister's bills if they're not able to get out and about. And then you have the legal authority to do that. So that being said, many people have wills already. But the question then becomes, do I have a good will or do I need to have it updated? And that's the starting point. And from a general perspective, and mind you, I'm going to be talking in generalities this evening because there's just so many things that have happened over the last few years in this area of practice that have changed the landscape totally. But again, going from general parameters, if your will predates 2015, then chances are there are things that need to be reviewed to make sure you're in compliance with the new laws and the way things are set up now. So, okay, so what do we do then? All right, so if you've already got an existing will, the document itself, I often get requests from people, can you take a look at my will and tell me what you think? And the answer is, quite frankly, no, because the document itself doesn't tell you anything about the background of your situation and how that document was arrived at. And that's really where the gold is. for me to do a good job for you or any other lawyer to do a good job for you, that's the first nugget that you need to look at. The process that you were put through to arrive at your will. So I talked to many clients, and their experience in the past has been they go to the lawyer's office, they say, I need a will, I have a wife, 2 children, what do I need to do? Hour later, you end up walking out of there with your will documents, and you think that you're now protected. If you've been through any type of scenario where the lawyer hasn't spent a lot of time with you, or indeed, if the lawyer hasn't spent any time with you, then you really need to look at it, because a lot of times, unfortunately, these things are delegated to law clerks or assistants to do the background information, and then you meet with the lawyer for the signing. That's a recipe for disaster. I've been doing this for over 30 years now, and I'm still learning every day. There's so many things that change, as I mentioned, that it's always a moving target. So when you're dealing with somebody about your assets, your estate, all that work that you put into building your wealth and looking to provide for your family, you want to make sure that the person on the other end is taking that seriously and getting to the nuts and bolts of what needs to be discussed to make sure that the job is done right. So the process is that when the lawyer meets with you, there's like 3 key areas that you need to get into when you're dealing with the family. The first is, for us to do a good job for you, we have to know about your personal relationships with each other, with your children, and with other people that are important in your life. So the meeting should have started out with gaining sort of a basic information of your understanding of those relationships, and to find out if there's any issues that we need to guard against when we're putting the estate plan together. Some of the issues that are through no fault of anybody's own, if you have a child with special needs, you'd be surprised how many times the lawyers never ask that question. And then you get a will that you think is going to protect your family, only to find out that the benefits are cut off when the person passes away because the trust that's required in that case isn't included in the will. And it's a huge difference if you don't have that trust included in the will. What they allow for without that is only a fraction of what you can do for your family. So that's one issue. Do your children all get along? A lot of times we'll see wills that'll have, if they have 3 kids or 2 kids, they'll have joint appointments, only to find out upon passing that kids hate each other or they don't get along. So in those situations, we want to make sure that we have one person in place and then the next person sort of as an alternative, or sometimes all together to take the power right out of the family and have a third party deal with the administration of the estate, so as to try and keep harmony within the family. Because again, I've heard it over the years a lot of times where mom and dad will say, well, the kids, they'll do the right thing when we pass. And I'm sure that they all want to do the right thing, but my experience has been that's maybe 1% of the time that ever happens. The reality is it's usually like adding gas to a fire. Everything kind of goes crazy and falls apart at that point in time. And that means everybody's getting a separate lawyer. That means your hard-earned assets are now going to fight a conflict. And then the relationship between your kids, if it was ever repairable, is usually gone at that point. So family understanding is the key. That's where we always start. Also, we want to know if the children have any residency issues, because a lot of times your kids are mobile because of their job or their schooling. And if you don't have the appropriate clauses in the will to deal with them, so if you appoint them as your executor, for instance, and they're now living in BC, and you pass, and you don't have the necessary wording in the will, even though you have a will, even though you've named your child as the executor, the first thing we have to do is get an administration bond, usually equal to twice the value of the estate, before we can even get started. And in practical numbers, you were usually talking about $3,000 or so just to get the ball rolling. Whereas if you had an appropriate clause in your will dealing with that situation, $0. So that's just another small point. So the initial intake process has to involve the relationship with your children, the residence, any special needs, all of those types of things. So once we get that information, then you would move on to considering your assets, the present assets that you have, where you're going, and then we try to find all the key players that are involved with your estate plan. So we want to know, like Steve, your financial planner. We want to know who your accountant is. We want to do an overview of your assets to make sure that when we set up the will for you, there are no surprises. We often run into a situation where somebody will have a jointly held asset, for instance, and they then go and make provisions under the will how they want to deal with it. only to find out later on that the will can't deal with that jointly held asset because it doesn't form part of your estate when you pass. So these are just a few of the questions that we go through. Another large issue or really big issue is tax liability for RRSPs, especially for self-employed individuals. If you have a pension plan, it's not such a big deal because usually your pension plan is your main resource for retirement. But when you've built up your RRSP and you have a significant RRSP, a lot of times people will end up between spouses. It's not usually an issue because they go, as most people know, it goes from one spouse to the other without any tax effect. But then when it goes to their children, they will have gone to a will seminar, something like this, but not with the same speakers. And they'll say, well, if I put a beneficiary on that RRSP, I don't have to pay probate fees on it. Well, that's not a good thing. Because what happens in that situation is, like, during your lifetime, if you take money out of your RRSPs, they usually take the taxes. Well, they do take the taxes off the top, and then you're dealing with net proceeds. But when an individual dies, the face value of the RSP is paid out directly to the named beneficiaries. So if you've put your 3 kids as the beneficiaries there, and we're dealing with a $600,000 RSP, which isn't atypical these days, they each get their $200,000, but now the estate's going to have to pay basically $300,000 in taxes on that. Now, what happens if these kids have gone and spent their money, and now the estate is here? If we don't have other assets to cover that, you got to try and get that money back from those 3 kids, or proportionally to what they received. And if they don't have it, then the other children end up paying the taxes for the ones that have spent it. So it's critical. So when we are doing our background information, we find out if you have that RRSP scenario, typically we name the estate as the beneficiary in that situation. So even though, yes, there's going to be probate fees on that, 1.5% basically of the value of those assets are going to go into the estate. The taxes are going to be taken off the top, and we'll be dealing with net monies for your kids. So there's none of those issues. And probate fees are 1.5%. So it'll be like $9,000 in probate fees, which sounds horrendous. But when we're dealing with the situation where the monies have been paid out and there's no money in the estate to pay the taxes, the fees are way more than that issue. So that's one of the simple things that we look for too. We also have to be sensitive on the asset situation to capital gains that you may have. So if you have non-registered proceeds, we want to make sure that you're aware of what those gains are. And when I'm doing my job, like, Steve is a great ally here, because I will say to Steve, okay, I need information on this, and we'll be able to figure out what the real monies are. Because if there's any couples out there, it's usually a situation where one of them does the finances and the other doesn't. So it always comes as a great surprise when we're having this meeting to find out what the assets are and actually what the tax liabilities are. And that's actually a really good point for the meetings too, is if I've had that before where people are so busy these days, say, well, can my wife come in and give you the information, or can my husband come in and give you the information? No. Really, in those situations, actually the meeting that you have together with myself to go through these actually is very cathartic for the people too, because it brings them up to date as to what's going on. And 9 times out of 10, they're always feeling glad about the fact that, wow, I know a lot more about my own situation now, or I didn't have an idea about it before. So we go through all of the financial issues to determine what are the issues here. Once we have all of that under our belt, then that's when we get into, okay, who's going to be the executor? Who are going to be your beneficiaries? Are there any special parties, any special charities that you want to involve? All of that kind of stuff, that's at the end of the day. So when I was talking about a litmus test for looking at your existing wills, again, just to repeat, if you went to the lawyer's office and the sum total of the conversation was your names, your kids, and what do you want to do with your estate, you've got problems. If you went to the lawyer's office and they asked thoughtful questions about your family, your assets, and after going through all of that, they gave you a will, chances are you got a really good job. And you can have some comfort in knowing that what you received from your lawyer is what you're supposed to have received. Now, that's sort of on the estate side of things for dealing with that. Are there any issues, Steve, that I've kind of covered that you have any questions about?
There's always more questions because it's an area that most of us have no expertise on. So yeah. Often the situations that we encounter you've already dealt with, where I will ask somebody, or somebody will say, well, I have a will. And I've learned from you to ask the questions. When was that will drafted?
Mm.
Oh, 1970, right?
Yes.
Has anything in your situation changed? Yeah, pretty much everything. So yes, I think you've covered a lot of good things in here, talking about, why it's important to know that that is updated, and just the documents you've had. One of the questions that we had was, at what age should somebody have a will? You had covered that right at the beginning, at 18 years old. A lot of 18-year-olds aren't thinking about getting a will or a power of attorney, but it's easy to encounter circumstances, unfortunately, where that might be absolutely essential and necessary to settling an estate. So I think you've covered those issues that you covered well. Obviously, since this is an area that probably none of the rest of us have in our expertise, that's why we're here listening to you, then we'll probably have further questions. And if people do have further questions after this, then they just need to contact me at steve.fox@ibcsecurities.com, and I'll be happy to get those questions on to you so that you can answer them for them.
Okay, great. Actually, while you were relaying that to me, actually, what I wanted to also explain why I say like 18, why you need the documents. I don't think I might have fully articulated why I mean that.
Okay.
It's because it's when the situation is after 18 years old, nobody has legal authority over you. You're an adult. And so if you're in a situation, and I hate to use it, but it's the typical one, is a car accident. Now the person's in a car accident, they're in a hospital. We need somebody to deal with their financials, deal with their apartment, close things down, make healthcare decisions for them. When you don't have a power of attorneys in place to deal with that situation, the only tool I have as a lawyer is to apply to court to have the parent usually appointed as the guardian for those individuals. And we can do that, mind you, but it usually costs about $10,000 before the case is done. Plus, the parent then has an ongoing reporting obligation that they have to do every couple of years for passing of accounts. Sometimes there's a bond that's required to be posted. So that's just for property, and healthcare is additional to that. And so you compare that situation to if the child had, or that the child, young adult now had power of attorney, it would be $0, because their parents then would have complete control over the finances, would have complete control over the personal care issues. And there's not going to be oversight by the government or anybody else as to how you conduct yourself. So that's really the importance of why I say, like, because kids don't really have assets then, so nobody says, why do I need a will? Oh, I'm sorry.
Somebody has a question already, apparently.
That's supposed to go through. That's the bat phone. But that's the big thing. Everybody knows about a will, but they always forget about the power of attorneys. And it's really the ability to have authority over the individual. And there is no short circuit to either you have a power of attorney or you have guardianship. There's no other tools that we have that can fill that gap. And the guardianship route is extremely expensive.
I've got several questions. If we get some time, hopefully we don't get cut off again. We have some time to deal with them. The first one is a question: what needs to be considered when choosing an executor?
Well, for sure. Honesty, ability, usually close relationship. Like normally it is your children if you're fortunate to do that. If not, then you would look for a close friend that fills those needs, that somebody you can basically trust 100%. Being local, which is often something people always ask about, is secondary, because with technology these days, we act for people all over the place that aren't local here, but are looking after people in Windsor or Tecumseh via power of attorney or an estate. And so that's really the primary criteria. When I was talking about my wills interview with people, this is where I try also to find out about the mobility of your children. So when you're talking about an executor that may have a job that's going to take them outside of the province of Ontario, again, it's not the the end of it, we can include the necessary clause in the will that would still allow them to do that if possible, if they have the ability, inclination to do it. So really, it's the bottom line is just honesty is the main thing, and then obviously there's other things that I don't know. I don't want to make it sound like if you have a child that has any type of vice issues, obviously not, you know, and we don't, again, the will's not the place where you hope for redemption or somebody's going to see the light. Usually nothing gets better with that process. So, and then also I mentioned that we try to find out about relationships with children. If you have a couple of kids that work together really well, then often it's really nice to have a joint and several appointment, which means that they're both appointed, but they each have individual authority. So when it comes time to dealing with the estate, they can kind of divide and conquer, or they can choose to work together, but it's up to them. And if something were to happen to either one, you've got the other one to kind of take over and finish off the job. So the relationship between the kids and the people too is super important. The only thing that I would caution people against, because of our proximity to the United States, is the US tax issues are a huge, huge technicality for us, because your executor, if they end up moving to the United States, that clause I talked about, if you live in a different province, doesn't help you out, because when you move to the States and you become a trustee for an estate, that trust becomes resident where they're living in the US, which attracts US estate law, which is really difficult to navigate and manage. So if you have a child that's living in the US, you can have verbiage in the will, but I would strongly caution against relying on that. You'd want to look at some other alternative appointment at that point.
That is you had no idea, but that was a great segue into the next question, which came in also by email, and it has to do exactly with that. This is if an executor lives in the USA at the time of disbursement of the will, but that person is still a Canadian citizen, so I presume they're dual citizenship.
Yeah.
But however, works, lives, and pays taxes in the US. So in a case like that, what implications are there in Canada and what implications are there in the US? And is this something that they should actively get advice on?
Oh, for sure. Yeah. And for US estate taxes, if you are actually resident over there, that it's residency that determines the taxation, not your citizenship. So yes, and again, now there's always, and the danger is always, I'm talking in generalities right now, because this area is fraught with there's a rule, there's the exception to the rule, and there's the exception to the exception to the rule when it comes to US. But the basic tenet is that, so if that child is the sole beneficiary of the estate, for instance, and they're living in the US, chances are, from a practical point of view, it's not going to be an issue, because when the estate is wrapped up, if they're the only beneficiary, there's no real trust period there that's going to throw us off on taxes. But if there's more than one child and they're the executor, well, the executor holds the money in a special capacity, a trust capacity. They don't own it outright. They're holding it in trust for the will. And that's where the US tax issues come into play. Canadian in the US has very limited exemption from taxes. They have estate taxes there. In Canada, we have none. So just the short answer to the question is if the child is the sole beneficiary and they're living in the US, probably not a problem. But if that child is not the sole beneficiary and is merely a trustee, and there's going to be any trust period in the administration of the estate, you'd want to look at other options.
Okay. So obviously, with your rules of exceptions and exceptions of exceptions,
yes.
Obviously we're not going to figure this out ourselves. This is something we want to get good expertise advice on.
Oh yeah, and I've been doing it for 30 years, and I'm hardly an expert on that area. I'll tell you, there's people, lawyers, they spend that's what their whole practice is Canadian-U.S. Interaction of the law. And they keep changing it in the US. So talk about a moving target again. It's like impossible to determine. Anything you're going to get from a lawyer now concerning Canadian US is an opinion that's got lots of caveats in it that say, well, based on what we know right now, this is what we think.
Yeah.
So I try to, if possible, I try to avoid the whole interaction with the US at this point.
Yep. Okay. The next one was typed into the chat. It says powers of attorney are often included in the will package. Any comments, read power of attorney for property and how to access that part of the package? Because as a social worker in ICU, the clause contact the lawyer to release the document does not work when needed. I don't understand that one. Do you?
Yes, I do.
Well,
Yeah,
that's
yeah,
what you do.
yeah. Yeah, unfortunately, a lot of lawyers don't have they have all these rules that are put in place for when you can access the power of attorney and stuff like. We don't do that. Actually, we provide the clients with the required documents right off the top. And the powers of attorney, the people that are exercising the power of attorneys, there's no fetters on the jurisdiction. They don't have to go to the lawyer to get access or whatever. Just on that question though, if you ever go to a lawyer and they talk to you about a will without power of attorneys, run, because there is no lawyer that should be giving you a will without power of attorneys or power of attorneys without a will. All three are necessary documents. And it gives you an indication of the practice that they have if they don't understand that, and then they're supposed to be advising you. But I can relate to this issue here because we've had some situations where the immediate care workers, like this person here, they're trying to help the individual out, and it becomes a real time is of the essence factor. And there's no real clear law on the issue, but from a practical point of view, what we've gone to doing now is issuing electronic copies of the documents to the people. And so when they're in the care facility, they say, hey, look, here's an electronic copy of the signed will. If your administration needs, or a power of attorney, I should say, sorry. If the administration needs for the chart a notarized copy, then we provide it. But if they know it's there and it's signed, they usually will act in accordance with it, and we kind of band-aid it afterwards by bringing the document in. If we do know that the person is going in for surgery or whatever, we always give them a notarized copy of their power of attorney with the living will statement in there so they can make that part of the chart right at the beginning of the admission process. So I'm not sure if that answers the individual's questions, but I understand the frustration for sure. We hear it all the time, and it's usually a practical matter that the procedure of the office governs.
We got an answer back in the chat. Yes, it does answer the question.
Oh, well, thank you.
Thank you very much.
One.
I'm not sure if this is related to that, but I've had some conversation with you at times and with some of our clients about clauses in the power of attorney for terms and conditions under which the power of attorney become active or don't become active. And you've expressed some of your concerns, and I've understood those concerns about how that may have worked practically in days gone by, but how that's radically different today. Maybe you can just explain a little bit about this, because as I see people's copies of people's legal documents, I often come upon this.
Well, that's great. Actually, we're talking about nuggets tonight. I forgot to mention that is actually one of the key things for looking at your documents. If any of you have a power of attorney that says it can only be used in the event that you're incapable, or it requires doctor's letters or anything like that, you need to get new documents immediately. Because from a practical point of view, I'm not sure if you've had experience with people with incapacity, and in situations like that, it's never a straight, I have capacity, I don't. It's usually always a moving target to try and determine it. So if you go to the bank's going to rightly say, well, how do we know that the individual is incapable at this point in time before we're going to let you take their money out? And then the only way that I can address that is through a court order. So I have to go to court, get all the evidence together to show that the person's incapable, and then we get an order to go to the bank to deal with the situation. Along that way, often the person will get better. So you just spent tons of money to try and get a power of attorney to work that has this condition in it, and the person gets better and we don't need it anymore. It is tremendously frustrating. Your power of attorney for property should say right in the document, it's effective from the day that it's signed. If it doesn't say that, you need a new one. There's no alternative. There's no other way to do it. That's the standard, and it's the only standard.
Excellent. Thank you. I got another question come in. It says, where does the trust come from after a person dies? Does it arise between the time of death and the distribution of the assets, or something else?
Well, great question. Sounds like an old law teacher. Who are you? Actually, that's a really great question, though, because people don't understand that when the person dies, actually, all of that person's property vests in the trustee named in the will, the executor named in the will. So it arises upon death. And that trust doesn't end until all of the assets are dealt with. So from the date of death to the date of final distribution, there's no ending of the trust. It arises automatically. It has a special name. It's called a testamentary trust because it arises as a result of a passing. And in the past, there used to be some significant tax benefits to a testamentary trust. That's another thing that's changed since 2015. A lot of my clients that have means, they used to put their kids' inheritances in long-term trusts, so they would be taxed more preferentially over a period of time. Now, the Liberals in 2015 changed it. So if you create a trust for your kids, 3 years after you die, every dollar that's earned in that trust is taxed at 50%. So not such a good deal anymore. So these are one of the things we talk about planning. We look for alternative strategies on how you want to deal with those funds. But again, that's something that is part of the new changes. So good question. Yes, the trust arises as of the moment of death.
Okay. You also mentioned 2015. So
yeah.
This was obviously a time when significant changes were made to estate planning law in Ontario.
Yes.
Maybe you can just touch a little bit on that. You've told me a little bit about it. Maybe you can just touch on that a little bit so that people have an understanding of why they may want to review their documents.
Okay. The biggest issue that affects most people is joint ownership. After that point in time, the Ontario, not the Liberals this time, but the Ontario government created this new form. It's called an estate information return. So whenever you have to get probate now, we can no longer just keep it private within the family. We have to produce a document at the end of the probate period that shows every asset right down to a knife, fork, and spoon accounting and the values that are there. And we have to, if you don't know what the values are, we have to hire appraisers to put values on items and pay the taxes on that. So you've got now appraisal fees and probate fees. So people will go to a seminar and they'll hear, well, if I put the assets in joint ownership with my kids, then I won't have to pay any probate fees and I won't have to go through any of that nonsense. Prior to 2016, that was the case. After 2016, it's not the case. After 2016, you have to have, if you have one asset, so let's say you put your house in your kid's name and you put some of your other bank accounts, but you forget about one asset. The new rules are that one asset will trigger probate on the entire value of your estate, especially if you only have one will. So what's happened since 2016, if you're using joint ownership as a planning tool, you now need to have two wills. One that hopefully covers all of your assets, but if you forget about something, you have it's called a limited grant of probate. We can restrict probate to that one asset to preserve the planning that has been done. But the other issue that arises whenever we talk about joint ownership here is once you make somebody the joint owner of your assets, as you know, they have the same rights as you to exercise control over those assets. If they go through a divorce proceeding, then your assets get dragged into their divorce proceeding. If they have creditors, their creditors can now exercise control over your assets. So what do? Joint ownership is still a valid tool, but to really round it out to make it work, what you have to do is you have to have a trust agreement with your kids. So when you put their names on as a joint owner, you also need, it's called a nominee agreement. It has a special name, and your kids are what they call bare trustees, B-A-R-E trustees. And it's a very special kind of trust because even though their names are on the assets, it's only for legal purposes. They have no control over those assets. Mom and dad are still the boss. And when you pass, those assets then are governed by the will. So joint ownership is the starting point, but to do it properly, you need to have two wills and you need to have a trust agreement. For the kids' perspective too, the other big issue is capital gains. So they have their own house and they put their name on mom and dad's house. And with the way that the property values have been going here, if you can't show that it's clearly a trust arrangement, Revenue Canada is going to say from the day that your name went on the house, if it's been a period of time and it's eventually sold on mom or dad's passing, if it's gone up in value, they're going to want to ding you for 1/2 of the capital gains. If you have that trust agreement because you're referred to as a bare trustee, it's as simple as that. CRA knows that because you didn't have beneficial use of the home, there's no capital gains for that kid. Even bigger is you put your name on mom and dad's house, and you know what? They go out and they find 27 friends, and they have a big party, and there's a loss at the home, and guess what? Your name's on the house. Well, your name's on the house, you're personally liable if there's a shortfall in insurance. With the trust agreement in place, because once again, it confirms you're a bare trustee, then you're protected from that too. So this agreement protects mom and dad from loss of control, creditors, and divorce, protects kids from capital gains and civil liability. So that's what proper joint ownership planning looks like. And if you have anything less than that in place, you're at risk of spending big legal money to try and deal with the situation afterwards.
Yeah, times are a little different today than they were in the past.
Huge.
You know,
Huge.
when we're taking a look at the baby boomers, you know, holding most of the wealth of this country, and then trying to pass this. Well, I want to say they want to pass it to the next generation as cost effectively as possible, but
Yes.
sometimes the simplest of mistakes can cost tens of thousands of dollars. So
Yes.
we want to make sure that people are aware of what those potential pitfalls are so that they can avoid them. Because, you know, somebody says, oh, if I'd known I had to spend, you know, $2,000 to avoid $20,000, that would have been a great move.
Good deal, yeah.
So it's just a matter of getting enough education to know, you know, who should I speak with, and you know, what should I do about these to avoid those costs.
Yeah, and to do all that stuff that I was talking about, it's not cheap. It's about $3,000 by the time we're done to do the multiple wills, property transfers, and all that kind of stuff. So the easiest litmus test that you can take as a person right now trying to figure out, is this good for you, is look at the value of your estate, the value of your home, the value of your assets, and times it by 1.5%. So let's say we have $1 million, between $500,000 home and some investments, you've got $1 million. That's going to be $15,000 in probate fees. You're going to have to spend about $3,000 to get probate. So now you're up to about $18,000. And then your kids are going to have to manage the estate as an estate. So there's a lot of time and further costs that are incurred. Whereas if you use the joint ownership process, you avoid all of those costs, and the kids are dealing with the assets as owners now. We don't have to deal with the estate at all. So from a kid's perspective, it's like a power steering. It's like makes things so very easy.
Mm-hmm. Someone else was following up. I got a couple questions, good questions here. Someone else was following up on the Bear Trust. Is the Bear Trust within the will or on the asset, example, the bank account?
Well, that's another great question. Actually, it's a separate agreement altogether. It's actually a trust agreement that's drafted and signed by the parent and the children, and it supports all of that. The bank doesn't care about that agreement. For them, they just are going to look at joint ownership, whoever is on the account, if that's who they're going to pay it to. But that agreement binds the child to then deal with that asset in accordance with the will, which is really important too, because if you have 3 kids and you only put 1 kid on the account and you pass away and they say, guess what, mom and dad love me more than you, it's my money. This avoids all of that altogether.
Excellent. The next question is, with a high level of taxation on RSPs at death, would a lawyer suggest the idea of naming a charity as a beneficiary for a portion of the RSPs? Or is that planning left to financial advisors?
Oh, I think properly to answer this, all of us, there's no domain when it comes to what I do. Like I like to work with Steve. Steve works with me. If you have an accountant, we usually involve that individual too. So it's sort of like a team approach to answering that question. And so the first starting point would be, to me, is do you have an affinity towards a charity that you want to benefit here, or do you just hate taxes? And once we get to the bottom of that question, if it is that you hate taxes and you do have a charity, well then, a charity is a wonderful way to deal with RSPs. There's others as well, but that's one of the best ways that we can mitigate the taxes upon passing.
Yep. So I'll as well, maybe want to speak to the possibility of the donation of appreciated securities in a non-registered account.
Yeah, absolutely. Yeah, so that's where we talk to you. Yeah, because seriously, again, I'm the lawyer. I'm more the legal guy. And then I appreciate having somebody like Steve because he's got this, what he does is finances. So together we can be a pretty good team to make sure that you're looked after.
Yeah. Okay. Well, tonight is not about us; it's about you. And we've had some great questions. I have no doubt that we probably could go on for another half an hour or two. But we're even though it was broken in pieces, hopefully we have a recording of all of this, and I'll be able to piece it together and post it online and make it available for people to either go back and review. To get answers to their questions, or if they were people who weren't able to make it on the call, that they'll be able to view it later. So I think we'll call it at that. But there's certainly we've only scratched.
Could I just add one last thing, Steve? I was saving one nugget for the end. One nugget for the end. Okay, all of you guys that do have your wills out there, you go to your will and look to see if you have an affidavit of execution attached to that will. This is a document that's signed by the witnesses that saw you do the will. Again, if you don't have that document with the will, that's going to tell you about the quality of the documents that you got. But from a practical point of view, why I'm saying this is when somebody comes to me with an estate and they don't have the affidavit of execution, my first task is to find out who witnessed the will and hope to God that we can still find those people to do the affidavit of execution at that time. Sometimes we get lucky. If we don't, it's going to cost you about $2,500 to remedy that error before I can even move the file forward. So at minimum, if a lawyer did a will for you and it's not in there and you have a good relationship with them, just say, hey, you know, heard from Grassy that we should have this document and they should do it for you and they shouldn't charge you for it because it should have been part of the initial package. So affidavit of execution, it's attached to your will. And then if you look at the last page of your will on the back, it's going to say that this will is Exhibit A to the affidavit of execution. If you have that, good, and you can have some peace of mind. If you don't have it, you need to look into the matter like now. Sorry, that was my last nugget.
Yeah, no, there's lots more nuggets. As I've had conversation with you from time to time, it's very enlightening. I learn new things every time I talk to you. And as you self-admittedly are constantly learning new things because it's an environment that continues to change and change and change and change. So, you know, it's difficult to keep up with everything. And certainly difficult for me because it's not my area of expertise. I have a general understanding of it, but that's certainly why we count on you.
Yeah.
So,
Thank you.
So if you're willing, we would love to have you back again sometime and talk more on this subject. There's so many components to it, and not that we would get into the nitty-gritty of different circumstances because it is very individual. Yes. But the concept, as I have understood it, is that the whole purpose of having estate planning documents are, one, that you can, as much as possible, avoid cost.
Yes.
Right? The whole
Absolutely.
purpose of doing properly drafted documents is that you're going to save significantly more money than not having the documents.
There's no question about it.
Yeah, and obviously that may not matter so much to the person who has the documents or doesn't have the documents because they won't be able to answer or won't be around to answer. But, you know, if the objective is to, and this is kind of where I find commonly that people tell me, as I want to keep as much money out of the government's hands as possible.
Yes, so, and the lawyers too.
So
I can take that. I got broad shoulders.
That's right. So if I can get good advice and spend some money so that I can avoid a significant amount of taxation. I know we include I consider probate to be tax. I know some people would argue that. But if we can spend money and get good documents and affect what we want to affect and then have peace of mind that it's actually going to happen that way, then obviously that makes your service extremely worthwhile. Yeah. So I thank you very much for your expertise. I thank you for your time, taking time out for us tonight. I appreciate it. You obviously dressed far more appropriately for this than I did. Next time, maybe I'll have to put a tie on.
I'll hold it against you.
But thank you again so much for joining us, Tony. We very, very much appreciate it. So thank you very much, everybody, for attending. And we will see you next week as we head into a new topic. And I hope that you all have a great night, and take care. Bye.
Thanks, Steve. Thank you, everyone.
Good night.